This is Jerry Tuttle talking about misconceptions about copyright for for-profit teachers. The for-profit world is different than the non-profit world, especially in copyright. You non-profit teachers can do several things in copyright that I can't do. You non-profit teachers should pay attention. You never know when you may cross over into the for-profit world. If you tutor or teach an SAT prep course for money, if you speak at a conference for a calculator company, now you're in my world. Here are 3 for-profit misconceptions. You can't use someone else's materials, we have no fair use, and we can't use more than 10%. We can use lots of things: facts and ideas, federal government works, works whose copyright expired, anything with permission, and best of all, our own copyrighted work. Here are 3 miscellaneous facts. We can use facts because facts don't belong to anyone. By the way, that bell curve graph in the lower right is mine. I have the copyright to it. Here are some federal government works. The Obama photos by a federal photographer. The graph is unemployment data from a federal website. We can use material whose copyright has expired. The rules are complicated, but for recent material, the copyright term is lifetime plus 70 years. Most of Sherlock Holmes' material is okay to use, except for his last 10 stories. Many authors are happy to give permission to use their work. Creative Commons is a place to search. In for-profit, just stay away from the dollar symbol with a slash going through it. Everyone can always use their own work, which is automatically copyrighted as soon as it is fixed in tangible form. This includes digital work. Here are 2 examples of my copyrighted work: an article I wrote and a project I did for another class. The second for-profit misconception is that for-profit teachers have no fair use. Fair use factor 1 is tilted away from for-profit, but fair use requires an individual assessment of all 4 factors. Courts have found fair use when the user has made transformative use for a different purpose, even in commercial cases. The classic court case involved rap group 2 Live Crew's parody of Roy Orbison's Oh Pretty Woman in an R-rated version. Here's an example I used in class. I used photos of Barry Bonds in statistics class. I'm using the photos for a different purpose than the photographer created them, so I feel this is transformative fair use. Here's another example I used in class. I play a short clip of Billy Joel's song The Entertainer, which talks about the length of a hit song, to lead into a statistics problem. I feel this is also a transformative fair use. Another transformative use is using the movie Stand and Deliver to teach calculus. Studies of court decisions have shown that transformative use generally outweighs the other fair use factors. Any educational use of otherwise entertainment media should therefore be for a different purpose. Misconception number 3 concerns the so-called guidelines, such as using no more than 10% of a document. But the guidelines are not part of the law. 10% never appears in the law. Several court cases have approved using 100% of a document. In Karios versus Prince, Prince the artist, not the singer, copied 100% of a photo. And in Perfect 10 versus Google, Google used 100% of images as thumbnails for searching. The Georgia State case on copying for e-reserves had the judge stating that even 18% might be okay, but this is a district court case in a nonprofit school and may not be generalizable elsewhere. Linking to a document rather than copying it is okay according to an industry expert and according to the Google case, but do not deep link, which may avoid the caveats of the website. Best practice is to do an individual analysis of the 4 fair use factors and document why you made your decision. There are checklists to help you in the thought process. Here are the citations for the material I used. These include the opening cartoon, which is licensed to me, and some of my copyrighted works. Thank you for listening.